From climate change to genocide and torture, the greatest concerns of our time are becoming the business of international courts. In the last decade, the International Court of Justice was faced with over 10 cases concerning the prohibition of genocide, climate change, the prohibition of torture, and the rights of workers.
The UN's highest court has ruled that climate change is an urgent and existential threat.
Lawyers for the South African government have outlined their case to the UN's top court, alleging that Israel's military offensive in Gaza amounts to genocide.
These cases represent something that we call public interest litigation. Litigation not in the interest of one individual or one state, but in the collective interest of many people or groups. Although public interest litigation is common nowadays, this was not always the case. Only 60 years ago, the same International Court of Justice did not accept a case brought in the public interest under international law. So, how did this shift in attitude happen? And what does this tell us about how change happens in our system of international law? My name is Mileva, and I'm an assistant professor of international law here at the University of Groningen. In my research on public interest litigation, I examine how new arguments about the meaning of the law bring about change in our international legal system. The increased frequency of public interest cases made me curious about how these cases came about and why they're so popular now. I was wondering what kind of legal or extra-legal mechanisms drive this change. So I first looked at public interest cases of the International Court of Justice to try and understand how this concept of public interest litigation went from not accepted in 1966 to commonplace in 2025. What my research indicated is that there were no new rules that enabled this shift. Instead, it happened through the reinterpretation of existing procedural and substantive rules. This gave me more information about how the change happened, but it left a bigger question unanswered. What made these new interpretations of the rules more persuasive than the old ones? And how does a new interpretation of a rule become the norm in international law? To tackle these questions, I turn to the theory of normalization. This theory tells us that arguments are gradually introduced and become accepted through their strategic reproduction in public discourse. Using this as a springboard, I want to examine whether in international law, normalization happens at the level of judicial interpretation. Many crucial questions about the meaning of international law and the rights and obligations of different actors are currently being decided in public interest cases. This often includes new interpretations of the law that may lead to fundamental changes in our legal system. At the same time, we don't yet have a full picture of how these new interpretations become accepted and how they reshape our international legal system. These are the questions that I will be working on here at the Faculty of Law at the University of Groningen. In my project, I intend to study legal interpretation not merely as an aspect of judicial decision-making, but as a crucial mechanism of change in international law.